Las Vegas, Nevada for the 2019 Mass Torts Conference. Joining me now is Andy Bederman. He is the chair of the AAJ Political Action Committee, PAC, also an attorney from the Washington, D.C. area, I guess. So, Andy, first off, let's start with what is the AAJ?
Okay, AAJ is the National Trial Lawyers Association organization. It's basically the National Bar Association, if you will, of civil trial lawyers who represent plaintiffs in their claims for compensation for all manner of injury, but especially personal injury against individuals, corporations, government, and so on. So AAJ stands, for the American Association for Justice. That's what AAJ is. I'm the volunteer chair of the Political Action Committee, and like most organizations in America, we also have a political action committee, which is the only nonpartisan political action committee in the United States dedicated to the preservation of the civil justice system. In other words, we keep the courthouse doors open for every American.
Right, and that's one of the themes, obviously, of why I've been coming here is because of that function. Like, why is that important? And, what does that mean? The courthouse doors open. Let's just start with why that's important, and then we'll get to the ways that that metaphorical door is sort of shut.
It's very important because the founders of our country contemplated and in fact designed a system in which every citizen had equal access to the courts and to the rule of law, regardless of their financial position in life. And that's what we do. I mean, when I say we keep the courthouse doors open, plaintiffs' lawyers like myself and those in AAJ do not charge a fee when a client hires us. We are paid on what's called a contingent fee basis, which means we get paid if and when the case resolves favorably for our client. And that to me is the great leveler, because it used to be that people thought they'd have to have thousands of dollars to pay a retainer to an attorney to get legal representation. With a contingent fee, which has been around at least 50 years, if not longer, you don't need that. All you need is a meritorious case and an attorney who's willing to take it, and you'll have access to the courts just like ExxonMobil, just like AT&T.
And okay, so how does the doors, these metaphorical doors, how do they get shut?
Well, it's a good question. They get shut, for the most part, legislatively. And there's been an effort, again, throughout my 40 years at the bar, been an effort by business and industry to do just that by legislation. So to give you an example, a common law that's has been passed in many states, but not yet federally, is a cap on damages, which has been advocated for a generation by business and industry. And a cap on damages does just that. It places a limit on the amount of money a victim can recover for what's called non-economic loss, which is injury to basically your injury and your pain and suffering. So for instance, in a state like Maryland where I practice, we have a cap that 30 years ago, was under $100,000 and has been escalated to about $1 million, but we still have a cap. Some states have caps that are $250,000. So I've had cases where people have been horribly burned, and the most that they can recover for their injury, not for their economic loss, medical expenses, lost wages, and have you, but the most they can recover for their injury and their scar, if you will, is about $1 million, when the case is worth far more than that.
And so, and we have many examples. People can go back and listen to the probably at this point dozens of interviews I've done with attorneys here.
Yes.
Where corporations will cut corners. They will. I mean, almost that's the best case scenario when we're talking about these cases. They'll cut corners and think they can think it won't be a problem. A certain amount of negligence. There's also cases where they know this product is going to hurt people, but they've invested too much in the marketing. They've invested too much in the development. They need to, they need to create shareholder value. They go forward and they make a calculation.
Yes, they do.
We may have to pay out X amount of dollars,
yes, they do.
But that's going to be 10%, 5%, 2%.
Right.
maybe 25% of our profits.
Mm-hmm.
And so caps at that point do two things, right?
Right.
One, it basically it makes it less viable for an attorney to bring the case because you need an enormous amount of money to fight an Exxon or a DuPont or whatever it is. So you need to have built a war chest or gotten a line of credit or whatnot.
Right.
And it also undercuts the functioning of civil litigation as a sort of second order regulation.
Yes.
Right? It
As a
doesn't
deterrent.
inhibit as a deterrent.
Yes.
And so that's why why caps exist on some level. So there is no deterrent to this type of behavior.
Right. And in fact, a cap in many cases is a disincentive to the corporation or whoever the defendant is, the person or the corporation that you've made claim against. It's a disincentive to them to settle because they know that if they go to trial and a jury finds for the plaintiff and is empathetic to the plaintiff and awards a lot of money, that most of it will be taken away to the extent that the award exceeds the cap. So it's really a disincentive to them to roll the dice. In states where there aren't caps, and you'll find that many defendants come to the settlement table much more readily and freely than they do in states where there are caps.
Do you does the AAJ PAC? Do you do work on this on a state level, or is it strictly federal?
Well, that's a good question. We raise money for federal races, for the Congress, the House, the Senate, and the presidency. And we help identify candidates who share our views about the court system, about equal access to the courts, and then we help them win election to office. And if they do, then we know where they stand on our issues.
Right.
We know where they stand on our issues. In the last election, we raised over $6 million. We supported 299 candidates for office. 85% of them won election. And we were instrumental in the election of the 40 members of the House, the 40 seats in the House that flipped from the GOP to the Democrats and hence placed Speaker Pelosi in the Speaker's chair and removed Speaker Ryan from the chair.
Now, Andy, I know you're a nonpartisan group. I'm going to guess, though, that Democrats tend to share your perspective more than Republicans.
We are a nonpartisan group, but practically speaking, most of the candidates that we support are members of the Democratic Party. There are some Republicans who share our views, and if there are, then we gladly support them. Give you an example. Senator Lindsey Graham is a great friend of the court system. Now, I've got nothing in common with him.
Right.
And I really, and in no way do I support him, but he is a senator from South Carolina. He's not going anywhere, but he has a guaranteed vote for us because he used to be a trial lawyer, and he understands the system and shares our views.
What are recent? What has been the most significant threat to the ability to bring cases in recent years? Has it been legislation? Has it been executive action, or has it been, frankly, just a judiciary that is been, seems to me, close to overwhelmed by conservative justice?
Yeah, I think it's legislation myself. I mean, judges will be judges. They'll make decisions, and they have tremendous power in our system. Executive orders less so. Legislation. I mean, AAJ, which maintains a lobby staff as well, last year dealt with, in the last session of Congress, addressed over 700 tort reform, 700 measures designed to close the courthouse doors, if you will. All right, one of them seeks to impose a $250,000 national cap on non-economic or pain and suffering damages, regulate attorney's fees, which would then basically be a disincentive to attorneys to take cases if they can't make what they need to make when the case resolves to justify the investment of their time and money in a case. There was a bill in the last session. I mean, the most salient ones were the one to impose a national cap, regulate attorneys' fees, and that would apply to medical malpractice, nursing home, and pharmaceutical or bad drug and bad medical device cases. There was a bill to make it. Most of these cases are filed in sort of like a class action. It's not. It's called an MDL. But there was a bill that would basically mandate that within 45 days of filing your case, you have to file with the court proof that you're going to win without the benefit of civil discovery or information exchange. And
So
that's
wait a
virtually
second. impossible
impossible to do.
So these multi-district litigation
Yes.
cases, so that's where, and we were talking to someone on yesterday's program about a case involving 3M's earplugs that they sold to the military. There are cases of damages, probably, of military personnel all across the country.
Yes.
Instead of all those issues being litigated in each state, they're wrapped up in federal
Yes.
court, and they're actually going to be tried in Pensacola.
Right.
In this instance, they could end up in any jurisdiction. And so I have two questions
Yes.
on that legislation. So one is that how do you, if you could prove the case in 45 days,
You can't.
why wouldn't you just prove the case in 45 days?
Because you can't, because as you know, in our system of civil litigation, right, the plaintiff files a complaint, the defendant files an answer, then you begin what's really a beautiful process called civil discovery. And the purpose of that is to literally allow each side to actually discover the other side's evidence. And there are a number of tools, written questions, document production requests, and depositions, which you've seen on many of your listeners have probably seen on television.
Right.
You know, where the witness is sworn under oath and is asked questions by the other attorney, right? And that's a lengthy process, and particularly in complex civil cases against large corporations, it takes months, if not years, to complete discovery. And typically, at the end of discovery, then, if the other side feels that it's not liable, it's going to file a motion to dismiss, right, which the judge then decides. Under this measure, which has not become law, right, you would have to, a lawyer who files a case would have to file prima facie proof, which is about 51%, right, that the defendant is liable within 45 days of filing. And that's virtually impossible.
I mean,
You know, so it's another way to close the doors.
right.
To eliminate plaintiffs and slam the doors shut.
So, and would that legislation basically say that there should not be discovery, essentially, or does
Well,
it
I mean, that's a
contemplate that
practical effect of
discovery?
it.
Right. Okay. Because, and people should
Practical
understand that what a company, you know, and just for example, Mike Papantonio, who from Levin Papantonio, obviously used to do Ring of Fire with me, and occasionally still hops on. Maybe we can get him this week here, but. He does a case against DuPont over the C8, and they basically back up an 18-wheeler with millions of pages of documents and say, good luck. And, you know, it comes from a firm that's a big firm that has a lot of money, has a lot of resources, has a lot of staff, and they actually went through the documents and found documents that even the 3M lawyers didn't realize were there, and
Right.
that's how this guy wins the case. The idea that you could do that process in 45 days
No, you
is
can't do it.
absolutely absurd.
It's virtually
so,
impossible.
okay,
It
so
is impossible.
so clearly that you know, that's basically a poison pill for why specifically MDLs? Why multi?
Because that's the venue. That's where all the bad drug cases and the medical device cases end up. I mean, they're all. It's really. I mean, an MDL is a tool that the court system has to make it easier to handle large numbers of cases. It's like a class action. In a class action, each victim has to have the same. Each victim had to suffer the same injury as a result of the same act by the same defendant, right? And if you are such a victim, and a class is filed, and you can opt into the class, and you can get your share of whatever the ultimate award is without having to litigate your case. And the reason that the class actions are not used in bad drug cases is because in bad drug cases there may be common liability among all the defendants. In other words, the same evidence that proves the defendant's liable to you would prove the defendant's liable to me, but the victims have different injuries
Okay,
of
so
varying degrees.
I
Right.
take a medicine that's been tainted with jet fuel,
Yes.
let's say, to use an example that we may end up having a conversation about while we're here, and the company that produced that medicine did the same act that got that medicine into your bottle and my bottle.
Right.
But for me, it gives me colon cancer.
Right.
For you, it gives you, gives
me a headache.
Gives you a headache, but it gives you maybe
Yes.
some type of like colitis.
A different
or
injury.
something. Right.
A different injury.
And so there's, and that's when you would need a multi-district
Right. And
litigation.
in a multi-district case, which really is where all of the cases that we talk about at this conference end up, virtually all of them, end up in a multi-district litigation, then you have the liability issue, which is common to all the victims, is handled commonly and once for the benefit of all the victims, right? But the injury part of the claim is obviously they vary from victim to victim, and they have to be handled individually.
And so they set up basically an algorithm, right?
Well, ultimately, I mean, if the case resolves, they set up a master, matrix, if you will, that's used to determine who's entitled to compensation and to what extent. But this measure, which was introduced in the Congress, right, which was probably hatched at Big Pharma or the Chamber of Commerce or both, right, would essentially close that door, because no one can really produce prima facie proof within 45 days.
Right,
It's impossible.
What's the biggest piece of legislation that is actually passed? That has there been any?
No, there really hasn't, and I have to say, largely because of
mostly on state levels where we see this, right?
But federally, right? Federally, there's been very little significant tort reform legislation in the last decade, and it's largely because of AAJ. Now, I would say the most damaging thing. I mean, there was a court decision about mandatory arbitration.
Right. Was that Concepcion and AT&T, or is that
think so, yeah. I believe so, and we're fighting to overrule that legislatively. That's probably the biggest bad thing that's happened is forced arbitration. But none of these other measures have passed. There's no national cap. The courthouse doors are still open, right? There's still MDLs, but there's a lot of time and energy and money that's been invested and will continue to be invested by business in America to close those doors. And it's a drumbeat that I've been hearing. I've been practicing law since 1978, and I've been hearing this nonstop since then.
And they've used many tactics, ranging from like taking a story. I don't know, maybe it was 4 or 5 years ago now. I had a documentary filmmaker on who was here, who had done a documentary on the famous hot coffee case from McDonald's,
right,
which was lampooned
right.
but it turned out when people hear the details of it, it's pretty nuts.
Yes.
And that's been an ongoing. I mean, what does AAJ do in terms of from a cultural perspective, right? Because there's theories out there that legislation and politics are downstream from culture.
Yes.
Trial lawyers. I mean, you call yourself a plaintiff attorney.
Right.
Because trial lawyers have been maligned, and it's
unfairly.
I couldn't agree more, but there was a specific agenda behind that.
Right. So the best that what we do is educate as best we can, and we tell our members. AAJ is sort of the mother organization of all the state trial lawyer associations. Each state has one, and AAJ is sort of the mothership, if you will. And we work closely with the state organizations. And for a long time, we've been trying to educate people on the state level. But the best education is when a doubter is suddenly a victim.
Right. Well.
And once a doubter is a victim, then the doubter looks at things dramatically differently. President Trump, for instance. I was just speaking in the session there about the work of the PAC, and I always talk about President Trump, who loves to litigate when it suits his needs.
Right.
When it doesn't suit his needs, he hates lawyers, hates the court system. But he's an example of a guy who knows that when the doors are open for an individual, and that individual needs them open, it's good.
What would you say, do you have a sense of which state is the most hostile to civil litigation?
There are a number of states that have $250,000 caps. I can't tell you the names right now. They tend to be states. I mean, the states that are more hostile tend to be more rural,
right,
with smaller populations and a history of real conservatism. Although interestingly, I mean, you had a state like Arizona where the right to, there's never been I believe there was a cap there that was held invalid by the state's high court because it contradicted the state's constitution, which guarantees everybody equal access to the courts.
Interesting.
And that's unusual for that state, which has a history of conservatism.
and that's a good dynamic that
Yeah.
the court would interpret. I mean, it's almost like a poll tax, right?
Yes.
In some respects, as applied to the opportunity to have recourse in civil litigation. All right. Well, just so let me just ask you this. I'm curious. You've been practicing since 1978. Has the behavior of corporate America changed significantly during that time, or is this a consistent animal that essentially each new endeavor, there's going to be a certain percentage of them that are willing to cut corners or to just nakedly ignore evidence that they have and are aware of that their product could be damaging, for example. Has that changed at all, one way or another?
Yes and yes. It's I think change on a national level is an incremental, slow process, just like legislation is. But I think some corporations have changed their behavior, but I think the vast majority have not. And what a corporation might have to pay victims, right, because of the failure of a product, really hasn't changed at all. I think it just remains an economic calculation for them, especially in the pharmaceutical industry, where the development costs are high, understandably. I just think they factor it in. That's all. A certain number of people are going to. Bottom line is they've invested so much money in the development of a product that they're going to do whatever they can do to keep that product on the market. And if they know or should know that there's going to be a problem with the product, they're just going to factor the cost of that into the cost of the product. That's simple. So things haven't changed that much, in my opinion. What has changed is the frequency with which they're called to account and ultimately have to pay. I think that's changed dramatically.
Has that gotten up, or
I think it's increased? Yes, I think you see it a lot more.
Is that because of just the level of sophistication of
I think it's because of the
plaintiffs' terms?
Because of the plaintiffs' bar, because of what plaintiffs' trial lawyers do. We keep America safe, and if it's not safe, we keep the courthouse doors open for you.
Well, Andrew Bederman, the director, the chair, I should say, of the AAJ Political Action Committee. Thanks so much for your time today.
Thank you
I really
for having me.
appreciate it.
I appreciate it.
Thank you.